Welcome to the Computational Antitrust podcast. My name is Teodora Groza. I am a PhD candidate at Sion Spor Law School and also the Stanford Computational Antitrust Project editor-in-chief. If you're new to the podcast, our project brings together over 65 agencies and more than 35 academics in our advisory board. Each month or so, we publish an academic article on the subject of computational antitrust. You can find all these publications open access at computationalantitrust.com. For those who've listened to the podcast before, it may be surprising that I am the host today. Now, the reason why I am the host today is that Thibault is going to be my guest. We are indeed discussing his latest publication, The Making of an Antitrust API Proof of Concept. Before we get started, I suggest we watch a demo Thibault prepared of his Antitrust API. Let's go.
Welcome. In this video, I want to guide you through the creation of legal decision trees and the making of related users interfaces. So, why would you want to design an interactive decision tree? The answer is twofold. First, should you work for a government or an agency, you could give all the companies and individuals access to your tree. And should they plug any software that they use to help with decision making, your tree will play the role of an API that automates compliance. Second, should you be a researcher, as I will show, making legal decision trees is a great way to identify where the law needs improvements. Alright, first let me start with a demo. What you see here is the end result. Users are asked to answer questions without legal jargon and eventually end up with a piece of legal advice. Go ahead, don't, or ask a lawyer. Now, here's how I created this API. As you are about to see, making such an API is what we called a no-code solution, meaning that it does not require any expertise in computer science. This means that any agency could design a similar API despite the lack of technical expertise or financial constraints. All you need is one person to code the legal field you are interested in, and importantly, to translate legal language into a language that non-experts can understand. Here, I coded EU competition law, meaning that I translated the entirety of the case law into different decision trees, one per practice. When users end up on the green square, this means that the practice is legal. The practice is most likely illegal when they end up on the red square. Once you have all your trees, you need to merge them into one and find a way to guide users towards different branches. You can't indeed expect users to choose what part of the tree is relevant to them, so using different questions, you need to direct users toward the practices that matter to each of them. When you have just one tree, you are ready to transpose it to a software that will make it interactive. Here, I used berkeleybridge.com. What you see above me are different nodes and ages, meaning different branches that are all linked together with yes and no questions. And that's it. You are ready to deploy your tree on your own website. If you want to play with the one I created, you will find the open access link in my dedicated article, linked in the description of this video.
And we're back. So, Thibault, could you tell us a bit about what an API is and what inspired you to write the paper?
Sure. First of all, it's good to be the guest for once, and I'm delighted that you are the host. So thank you very much for doing that today. So as I explain in the paper, the API is meant to assist companies. An API is, in the true sense of the term, a software that may allow you to connect to existing digital infrastructures, right? And here, what I mean by API is the ability for companies to connect where they make decisions. So it might be that they use a software or that they have human with antitrust expertise with the antitrust law and all the body of all the case law. So the reason why I got the idea for this API is that, as you know, we've been running the project for 2 years, even more than that now. And I realized that very few of our publications were actually providing solutions to companies. Most of our articles and publications have been focusing on the agencies, which is great, because there is clearly for part of the economy a divide regarding what some, especially big tech companies, can do with computational powers and what the agencies can do on their own. That said, I wanted to show how computational antitrust can also benefit the agents that are subjected to antitrust, and especially small and medium agents, not necessarily the big companies. So that being said, I do believe that agencies have a role to play, so they are not entirely out of the loop in this article. And namely, that role might be to develop similar APIs to the one I present in this article and do that in their own jurisdictions with the goal in mind to offer a first compliance tool to all of the companies interested. And that explains why I did not rely on natural language processing (NLP) to build this API, because this kind of expertise is very scarce and expensive. And I know, and we know, that some agencies may struggle to hire computer scientists with NLP experience. So I wanted to make it easy for agencies to justify the creation of an API internally. And that is the reason why I thought that I would try just to do it in what we call a no code solution, right? So a solution that does not require computer science expertise. So in the future, as I mentioned toward the very end of the paper, I will develop a similar decision tree, interactive decision tree, relying on more advanced techniques of NLP, and I will compare the results. And only then, if the results using NLP are much, much better, it would make sense to invest the space and not to use the technique and the methods that I present in this paper today. But I doubt it will be. We'll see. And by the way, something I did not do yet in this article, and that I think should be done, is the coding of Article 101 of the TFEU. I've done none of that. Merger control, although I think it's a very natural space where you may want to create interactive decision trees, isn't there. Market definition, remedies, procedures, and in fact, anything that is outside of EU law isn't in that tree. Now, it seems that it could be harder to code US antitrust, for example, because it's not based on rules, or at least not framed in a kind of a way that we do in part of Europe, and especially in the Latin countries. But I'm not sure it is actually, because if you look at EU competition law, well, most of the law is actually written by the courts, right? So it relies on more of an emergent process, which seemingly is harder to translate. And yet, the API that I offer, I hope, shows that it's possible to reach a result that is hopefully good enough. So if you are in the US or in any other country in the world and listening to us, go for it. The article explains how to proceed to develop such an API step by step. So it's here for you.
That's fantastic. Well, two things I love about your paper are one, that you privilege the zero code solution to make it accessible to anyone, regardless of their coding capabilities. And also that the article really shows that the project is not purely agencies oriented, but also opens up the space for law firms to explore how computational antitrust tools could improve antitrust compliance. I think that your paper is not only very innovative, but also very humble, in the sense that you talk a lot about the limitations of the API. One of the things you mentioned is that a key challenge is how to capture the state of a legal system in computer code. Could you tell us a bit more about why it is hard to translate the law into code, and what, if anything, gets lost in that translation?
Sure. It's been researched for a very long time, and actually, some scholars in my home university, the VU Amsterdam, have been doing that for more than 40 years. So I'm far from being the first to try to do so and embark on this journey and to face the issues. Now, I think there are several misconceptions to be addressed. I will try my best to do it in a way that is comprehensible. The first is that the law, or some people would say that the law can never be translated into code because the law is way more nuanced, right? That's what you hear often. And I think this is often wrong. To be sure, this is true for the kind of subjects that we, the scholars, like to research. Why? Because why would you research something when the answer is obvious? But if you practice, and I had a chance of practicing antitrust for 5 years, you will, and especially if you do so not in a super big law firm, you come to realize that most of the questions that you have to address are, for you, the lawyer, easy to answer, and you have to put it in a way that your client can understand. But it means that often you can code the law, that is, translate the law into computer code that is often expressed in true or false statements, which again mimics the work of practicing lawyers in not such big law firms. The second misconception is that code is black and white, and that therefore it would become impossible to use it for the purpose of translating legal rules and standards. And I think, again, this is wrong. Now, I don't want to be too technical, but the underlying functioning of the machine, the computer, relies on machine code, which indeed is black and white, right? It's a bunch of one and zeros. But if you move to assembly code or interpreted language, such as Python or C++ or any of the modern languages that we have running the softwares on our computer, well, those are not relying on black and white. They are actually way more nuanced than that. So I think here you find a level of granularity that is convenient to express legal rules. So that was the second one. Third, we hear that because you cannot translate the entirety of the law into computer code, it is not even worth trying. And to that, I have two answers. First, I think that coding substantial parts of the law and pointing out to users when the law cannot be coded is already a great step forward, and it's worth our time and effort. Second, you don't always have to translate the law per se. What you can do is that you can use the regulatory force of code to reach a similar result than the legal rules and standard without having to, again, properly translate the law. I'll give you two examples. Some of you might be or may recall the time when we used to exchange and buy MP3s, right? This was one way of listening to music back in the days, before the streaming era. If you were to buy those MP3, and by the way, still the same today, if you are a subscriber to Apple Music, it's not MP3, it's M4A, but it's a different format. What you can do is have a file on your computer, but if you try to send that to your friend, it won't work. Why? Because there is a piece of code, DRM, embedded in the file that is not a direct translation of copyright law, and yet the result is the same, right? You can only listen to music without infringing copyright law if you are the owner of that music. A second example is Netflix. I'm sure many of you have tried to screenshot beautiful pictures in movies and TV shows, and actually Netflix will prevent you from doing so. It will actually just give you a black screenshot, which again is not a proper translation of copyright law, but ends up in a similar place. So you don't always need to translate. Fourth, and the last, I think the last of those misconceptions is that to the idea that without turning the law into code, then you avoid any translation issue. And I think this is wrong. And I already alluded to that. And this is wrong because there is, in any case, another translation that is at least as problematic as the first one and rarely discussed. This is the one where you have to translate legal language into day-to-day language, right? And I face the issue when making the API, and I mentioned that in the article. I say, well, if you are making an API for companies to use, let's say without antitrust expertise, and ask them, are you interested in assessing whether or not you are engaging in pure and or mixed bundling? Most likely they will say no, and in any case, they won't understand what you are talking about. On the contrary, if you translate that and say, are you interested in trying to assess when you are selling two products only together, which is pure bundling, and when you are selling products together and also separately, which is mixed bundling. Are you interested in assessing whether or not you are complying with the law? Then they may answer that they are, and in any case, they will understand your question. So that's another translation that we have to engage with. You lose some of the precision of the legal language, and yet I think we have no choice but to do it.
Okay, thanks a lot for this very structured exercise in debunking myths about law and code. I think the examples were very helpful in showing our listeners how we are actually trapped into thinking that law and code are incompatible when actually the relationship is way, way more compatible than we tend to think about it. I want to move on and talk about some observations you make in the paper about competition law in general and how your work on the API has exposed some things about the nature of competition law. So you mentioned that the current design of the rules often expects companies to have information which they cannot possibly have access to, and also that agencies should maybe consider giving companies more information to enable them to assess compliance with competition laws. Can you tell us a bit more about how more information could actually make compliance easier, but also about how competition law expects companies to have information they cannot possibly possess and what threats that poses to enforcement?
Sure, of course. I think in some cases they cannot have the information and should not, which is even more worrying. Why? Because if they were to have this information, they could probably potentially use it to infringe antitrust elsewhere by way of implementing cartels. But I'll be more specific in a minute. Just if I reflect a little bit on years of teaching competition law, of course, if you do that, you have a sense, hopefully, you will have a sense of the limits of competition law. Now, I must confess that the making of the API made those limits clearer in my mind and put some order there. And I came up with three limits when trying to comply and or assess compliance with competition law rules. The first is indeed what you ask in your question, the lack of information. I'll give you an example. Um, it might be that some companies will not collect all the information the companies can have, and therefore won't be in a position to assess compliance with antitrust. In the case of predatory pricing, for example, you're asked to assess whether or not the final price of your product is above the long run average incremental cost. And it seems to me that this is the kind of information you should know as a company, right? And if you don't, well, you won't be able to assess compliance with antitrust, but it's your fault, nothing we should do. On the other end, it may be that we sometimes ask for information indeed the company cannot and or shouldn't have. I give you another example. In the case of margin squeeze, companies have to assess whether or not their competitors can cover their costs, right, after paying to access the infrastructure or the upstream market. And that, I believe, is information that the companies cannot and shouldn't have, because otherwise it put them in a very dangerous position to be able to assess precisely the thin margin that their competitors have to stay in order to survive. And this is what I think we can change, right? So change the legality test, not to ask for companies information they shouldn't have. The second issue I found is that sometimes the companies may lack the expertise if they are not willing to spend an enormous amount of USD, euro, whatever the currency might be, to acquire that expertise. And I'm not suggesting that we should make antitrust law dumb so that anyone without expertise can just assess compliance, because there is one good way of making that, by the way. You say that everything is legal or that everything is illegal, in which case, well, no expertise problem. But to be more specific, when it comes to economic expertise, in the case of rebates, they are only illegal if they exclude as efficient competitors. Now, you have to have the economic expertise to be able to understand what it means, to calculate that. It's not that easy, right? Because it has to be as efficient proportionally to the size of each companies. And I am under the impression that we could come up with a better legality test than that. And some other times it is related to the legal expertise. In the case of exclusive dealing, the question is whether or not the practice is imposed on, I quote, many customers and over the long term. The many is something I may be able to assess as a competition law professor, right? So I know that many doesn't mean one. And I know that if you have imposed that on 100 customers, it might indeed qualify as many. But I'm pretty sure we could do better than that, especially knowing that we've been applying that rule for decades. So certainly the case law is specific enough to change the phrasing and actually say, well, is it more than 5 or more than 40% of the market, whatever we may found to be relevant. The third category, and I will finish there. Some other times, the nature of competition law rules are problematic, and often this is the case because they probe the future, they question the future, right? So they ask for companies to have a crystal ball and to say, well, I see the future, therefore I know that my practice is or is not anti-competitive. Now, should we change that? I'm not too sure. On the one hand, I think we shouldn't make the law computable or translatable into code just for the sake of it. Because, in fact, if we were to do that, antitrust would be, as I explained in the article, just a compensation machine, right? We will just look at the past and say, oh, you suffered from a practice. Sorry to hear. Here's the money. Now go away, right? So we don't want to do that. We have to be forward looking. On the other end, I do think that the inability to compute the legality test here or the rules may, I'm not saying it is, but may indicate the inability to comply with the law because the inability to understand what this is all about. So what I suggest is that for all of those rules trying to question the future, we should make a divide whether or not it is actually feasible to assess the rule in the future if we have some factors that make the question predictable and workable or not. If not, I don't believe we can punish companies in a system that relies on the rule of law as opposed to the rule of maybe, which is a bit of what we have sometimes in competition law.
Well, thanks a lot for exposing how the law is actually ripe with all these uncertain standards and draft approximations, which only make it harder for companies. Now, I'll just go back to your discussion about crystal balls and ask you to imagine having the crystal ball. So, if in some distant future we could imagine that similar APIs could be built for roughly the bulk of the competition law doctrines, what would be left for antitrust lawyers to do, both on the compliance side and on the enforcement side? Do you ever think that antitrust will become a sort of do-it-yourself regime where you just use the API and then that's it? Or do you think lawyers will always have a role to play in the competition law world?
Something I think I quoted this baseball player many times in the podcast already. Prediction is hard, especially when it's about the future. Now, what I discovered recently is that he said something different, which is as equally dumb or stupid, but in fact might be deeper. He also said you can observe a lot by watching, and this is what I try to do here in the space, right? We together and with the team are in touch with so many agencies and can observe and see what they do and answer their question. And from that, my impression is that um, first, they indeed want to provide companies with the tools to assess compliance with competition law, right? Agencies want indeed to decrease the amount of anti-competitive behaviors. And the vast majority of companies also do not want to infringe antitrust, right? It is unlikely that a company will be created for the purpose and or that down the road, you will see a desire to infringe antitrust. This I know this often comes as a surprise, especially to first year students who have been exposed to only infringements for pretty much their entirety of the lifespan in the law school. So most companies want to comply. Now, a minority of companies are knowingly or unknowingly infringing antitrust, which means that I do not think antitrust can ever become fully automated slash self-assessed, right? And in fact, you may see some adversarial techniques and strategies where if you provide them with the API and the tools, it will become even easier for them to know how to escape those rules. Now, in the future, I do believe that more and more of the analysis will be automated. For example, I think that we will see in the future, not in 2024. I will be very pleasantly surprised if this was the case, but in the future, that agencies will rely on zero knowledge solutions, where they could, for instance, compute market shares if they were to get access to all the sales of all the companies in a specific market without necessarily having access to all the exact numbers, right? Because we may deem that to be business secret. But with zero knowledge solution, it's actually feasible for the agency to assess just the result, which would be, the computed market share. And similarly, we talked about companies, but I also want to put the law firms here in the mix and say that if they were to get access to the code of their clients' websites, and out of that automate web scraping techniques, they could flag antitrust issues such as collusive prices, if you were to scrape different websites and compare the evolution of prices over time, but even tying, bundling, all those things that may fall under the enormous gigantic concept of dark pattern. Everything is a dark pattern those days, but it may include antitrust law infringement, and some of those can be seen in the code. So if a law firm gets access to the client's code, the law firm could certainly detect that and say, well, please change that, or else you know that you are infringing antitrust. So I think the future is to be more automated. It does not mean that the human will be out of the loop. I think it simply means that the human who does not rely on technology will be out of the loop. So I think the overall lesson is don't be a dinosaur, because the dinosaurs disappear, but be a computational antitrust lawyer or enforcer instead.
Just to push you a bit on that, do you see in the future a bit more dialogue between the companies and the agencies? Do you think we can maybe step out of this very adversarial competitional world we have right now?
I think it's a very good question, because it's at the very core of what we've been trying to do, and of course you are very very much aware of that at the competition antitrust project, right? Which is to bridge the gap and or the divide, and try to develop solutions that benefit everyone, all the players, the agencies, the companies, and eventually the consumers. And this is certainly what you will see with an increasing dialogue between the companies and the regulators. The dialogue may be helped by more APIs, sending data, assessing the data. You could imagine that the agencies will not always have to use very coercive methods, right? But raise flag, send signals to the companies. I do understand the dangers, and we've published many excellent papers on the needs for us to properly frame the power of those agencies in this context. But yet, I think we have no choice but to go in this direction, which, if done well with good guidelines, will benefit both the companies, the agencies, the consumers, and the entire planet. Right. So, I would say yes to your great question.
I think that's a great point, and it really encapsulates the spirit of the project, that we are interested in public welfare, and that encompasses agencies, companies, academics, and the whole competition world. Now, just to finish the discussion about the future, do you maybe want to tell us about what the project is working on for the next months? What should we expect?
Sure. So more of the same, and more of not the same. So some surprises. What I can tell you is that we have some great paper coming, that we will keep on doing our best to publish on a monthly basis. We will organize a annual conference number 3. The format will change slightly, but the spirit of it will remain very much the same. Open access, no fees, probably online with some sort of physical components to that. And we are also working on several sub projects, in a sense, where we are trying to, for once, map all of the legal tech that may be specifically designed to address antitrust issues. And some members are already working on trying to combine all of those solutions into a database that will be made public. So that's one I can disclose. We are also working with some international organization in trying to better get in touch with agencies and gather what they do in the space, but I can't tell you much more than that. And something, if you joined us in the second annual conference, December 2022, which was discussed in the very last panel, the idea of creating a hackathon is something that we are exploring. So by all means, if you are interested, if you have experience organizing hackathon, feel free to get in touch with us. We will always answer your email. So yeah, thanks for the opportunity to mention all that.
So lots of exciting things ahead. Well, thanks again, Thibault, for sharing your thoughts on your paper. And for our listeners, stay tuned for our exciting future projects.
See you.